think we have to do the waiver.
I wasn't sure if we did or did not, Your Honor.
Yeah.
Good afternoon, Your Honor. Raymond Cook for the people. Your Honor, the people would waive any potential conflict between this honorable court and the Office of the Public Defender. While the people not that any such conflict exists, waiver in the avoidance of all doubt.
Good afternoon. Assistant Public Defender Nicholas Buckovich. Likewise, the Office of the Public Defender does not exist that any conflict exists between this court and the Office of the Public Defender. However, we do waive any potential conflict.
All right. Thank you. And the court, for its part, does not believe that a conflict exists either in the admission decided there or there. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus B.J. Moody.
Good afternoon, Your Honor. Raymond Cook for the people.
And good afternoon, Your Honor. Attorney Matt Hauser here on behalf of Mr. Dan DeMoody.
Sir, can you please state your name, please?
VJ Dan DeMoody.
All right. Mr. Hauser, this is your motion.
Yes, thank you, Your Honor. I guess first off, just a few updates since the motion was filed. First off, as it relates to paragraph 7, the mention of the trip to Iceland, that has been canceled, so that's not going to occur. But there is some travel to Tampa, Florida, August 14th through the 16th. And my understanding is that was approved by the circuit court already.
Right.
As it relates to paragraph 8, the trip to India has been canceled, so I would strike that section. And then I have dates as it relates to the travel to Atlanta, Georgia in paragraph 9. That would be November 27th through the 29th.
All right.
And
before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Now here's where this hearing starts getting really interesting. The defense isn't just asking for permission to travel. They're also pushing for the complete removal of the defendant's GPS tether, arguing that he's remained compliant and that this case involved electronic communication rather than any physical confrontation. But as every experienced courtroom observer knows, good behavior alone doesn't always erase judicial concerns. The judge must balance the defendant's request against public safety, victim protection, and the original reasons those probation conditions were imposed. Will compliance be enough to earn more freedom, or will the court decide that caution still comes first? Stay with us, because the judge's reasoning could completely change the direction of this case.
Then beyond that, I would stand by the motion that was submitted, request that travel be granted, and more importantly, that the GPS tether be removed as a term of probation. At this time, everything has been going with Mr. Dan DeMoody since the last time we were here. There's been no alleged violations, and as the court is aware, the subject matter of this case was electronic communication, and never any allegations of any physical presence. So we'd ask for that GPS unit to be removed. Thank you.
Teresa Claire, I'm information. Your Honor, I just wanted to provide to the court that I did have a conversation with the victim in this case regarding a motion that was filed about removal of the tether. While she doesn't oppose that the tether be removed for travel purposes.
You said does not?
She does not oppose that it be removed for travel purposes. However, she is asking the court to have it put back on upon his return.
All right. Anything from the people on this? I don't know if...
Your Honor, I would just agree with what the position of probation. I would ask that the court follow that recommendation. You have no objection to the travel request or for the request to remove the tether during that travel, but would ask that it come back on once that travel is concluded.
All right. The court, in reviewing everything and doing it, I am not going to remove the tether from the defendant. The tether will remain in place.
And just like that, the courtroom takes a decisive turn. Even though the defense emphasized the defendant's compliance and argued that this case involved no physical contact, the judge makes it clear that probation conditions aren't based solely on recent good behavior. The victim's expressed fear and the court's responsibility to prioritize safety carry significant weight in this decision. That's an important legal principle many people overlook. Probation is a privilege, not a right, and judges have broad discretion to keep protective measures in place when they believe they're still necessary. Do you think the judge made the right call by putting victim safety first? Or should the defendant's compliance have earned him more freedom? Let us know your thoughts in the comments.
There certainly were, at the last hearing, some concerns expressed to the court by the victim in this case, where while it may not appear to have been necessary, she felt it was necessary to move herself because of a fear of the defendant in this case. So I think that the tether, given those circumstances, is appropriate. With reference to the travel, I will permit the defendant to travel to Tampa. And what month was that, counsel?
Your Honor, that was August 14th through the 16th.
August. Got it. Tampa, August 14th through the 16th. And other trip to
The other one was
November. Go
was
ahead.
Atlanta, Georgia, Your Honor, and that's November 27th through the 29th.
All right. And the defendant may travel to Atlanta November 27th through the 29th. That includes his travel days, counsel.
At this time, yes, Your Honor.
All right. The defendant, I will not require the defendant to have the tether on during travel, but upon his return, that tether must be placed back on the defendant. I will continue all terms as previously ordered. I'll set his next review hearing for November 2nd, 2026 at 1 p.m. All right. Anything further?
No, nothing further this time, Your Honor. Thank you very much.
Thank you.
Thank you.
Enjoy the rest of the day.
This hearing is a perfect example of how judges balance a defendant's requests with the court's responsibility to protect others. While the court approved the defendant's travel plans to Tampa and Atlanta, it refused to permanently remove the GPS tether, deciding that the victim's safety concerns still justified that probation condition. Instead, the judge reached a middle ground. The tether could be removed only while traveling and had to be reinstalled immediately upon the defendant's return. It's a reminder that compliance alone doesn't automatically lead to relaxed probation conditions when public safety and victim protection remain factors in the court's decision. What do you think? Did the judge strike the right balance between granting reasonable travel and maintaining accountability? Or should the GPS tether have been removed altogether? Share your thoughts in the comments below. And if you found this courtroom breakdown insightful, don't forget to hit the like button, subscribe to the channel, and turn on notifications so you never miss another jaw-dropping courtroom case.
You do the same.
Thank you. Bye.
Court does call the case. People versus William Bridge.
Here's clear on behalf of probation. Your Honor, Mr. Bridge is scheduled before the court for review. I was contacted by the girlfriend. She indicated that Mr. Bridge went to work today, that he needs to get monies today, by the end of the day, to keep their lights on. I believe that they have one working phone, which she was in possession of. So Mr. Fridge is not here. Given that Mr. Fridge is compliant health wise, probation is just asking that the court send this over to a new date. I do know that Mr. Fridge has been struggling financially. They've homeless for quite some time, and now they are trying to work through some bills that they're behind on.
All right. What date would you suggest I?
Your Honor, I guess maybe approach August. Maybe August.
All right. I'll adjourn this matter to August 10th, 2026, 1 p.m. Court calls the case, People versus McKinsey Nyquist. We're no. Really? Really, Alan? Really? Really? You're good. I know. That's not Miss Nyquist. I figured
Thank
you
you
were
for
in
calling
here.
Language
I
Line
figured
Solutions.
that was
Thank-
not Miss Nyquist. And so I'm like, Alan, gonna take a student in. All right. I was gonna let it happen. Go ahead.
Good afternoon, Your Honor. My name is Elizabeth Braun-Jay, and I'm a University of Michigan law student working with this
Sorry to hear that. Go ahead. I'll have a lot to say. Go on.
working with the Civil Criminal Litigation Clinic. Pursuant to Michigan Court Rules 8.120, I'm requesting permission to represent Ms. Nyquist under the supervision of attorney David Santacroce.
Where are you from?
I am originally from the South, but I went to undergrad at University of Washington.
Is there a state called the South? Is that no? No, I just thought I lost some. What part of the South?
South Carolina, Georgia, Florida Panhandle. We bounced around.
You just kind of wandered or what?
My dad worked in aerospace engineering, so
Oh, I see.
wherever there's a Boeing, kind of.
Got it. Okay, so you moved around there, and then you said you went to, where'd you go to undergrad?
University of Washington in Seattle.
Your dog?
I am.
Gotta go. And then you came here.
Yes.
Okay. Well, welcome aboard.
Thank
Right, permission to practice is granted.
you. Thank you.
Where's your client? Coach, he sent you up here at Port Benchworth. Go ahead. He's just throwing you to the wolves. First, Alan was going to arrest you.
A rough day.
You were having great.
We have been in near constant contact with her. She did notify us yesterday that she was in the hospital. She confirmed that with us this morning, but we've been unable to get a signed doctor's note. We are working on getting that for the.
And truth to on
Yes.
probation. Your Honor, I also received a voicemail from Ms. this morning that she at the ER and that she was being admitted to the hospital. I attempted to contact her right back. However, was only able to leave her a message. I did indicate that message that I needed verification of the hospitalization, which I have not received. Given that Ms. Nyquist is non-compliant, and that she's not here and there's no verification of her hospitalization, probation is requesting a bench warrant.
My understanding also, she's on probation in Monroe County.
She is, Your Honor.
And is she compliant? My understanding is she's not compliant with that.
Your Honor, she's semi-compliant there. I have spoken with the other PO in that county, and Ms. Nyquist doesn't present very well when she goes into that. It's my understanding that she comes in. Not that that's directly a violation, but probation isn't like a given either. She also has another pending case out of Monroe. I do know that that date happened before for incarceration for the first violation. that she was sentenced to jail time on her. I shouldn't say first violation, because the court has been lenient with Ms. Nyquist along the way. However, there is that pending case as well. So I don't know where she stands with probation there, except that she did check into report with attitude, quote unquote.
Okay. That sounds more like her. I just want to make sure that I'm seeing this all correctly. That she has a new offense.
She does, Your Honor. She has a new case. That date of offense happened on May 6th. She was before this court on May, which she was sentenced to 13 days in jail with credit for 13 days that she had served by that date for the violation. Now, with speaking with Ms. Nyquist, none of that other case was even disclosed to my office to know that took place. Obviously, that new offense is clearly after her sentencing. In this case, she was sentenced back on April 6th.
And that new offense is what?
The new offense is an alleged malicious destruction of personal property under $200. I did provide a copy of that police report to the court of the allegations, the threatening, intimidating behavior, which basically, in short, alleges that she went to the victim's home on the Monroe County case and threw a wrench through his window. He is the victim in the case for Monroe with the domestic violence. They are
right.
Charged with a different victim here.
Sure. That's right. Right. Okay, they whispered in your ear. Want to tell me?
We are asking that the court not give weight to those allegations at this time, especially because at this present moment, she's presumed innocent in that matter. They're only allegations.
Leave it to somebody from Michigan to throw out that presumption of innocence. Go ahead, I'm listening.
We understand that a probationer can't be found in violation merely because they were charged. Instead, the court must determine whether the underlying conduct occurred, not just whether law enforcement has brought charges. So we are requesting, since at this point the state has only provided a police report a week to set this out so we can get verification of her hospital stay and that so she can be present.
Well, and certainly you've accurately stated what the court would do in the normal instance. And I might give some leeway were it not for Ms. Nyquist conduct both here and in Monroe County. And she appeared before this court back on May 18th. So, I mean, what I believe is, and I don't have a problem allowing time for you to get the medical information into the court. But what I will do is I'll issue a bench warrant for defendant's failure to appear today. Bond will be set the amount of $25,000. I'll give a 10% privilege on that. I will not, today is what, the 13th?
Yes.
I will not enter, that warrant will not enter until July 15th.